Protector, Professor Thuli Madonsela, is due to hold a briefing about a dispute involving the will of her late husband, Richard Foxton. His first will said his estate should give her 10 million rand and a property in the Western Cape that's also worth 10 million rand. Then a later will, I suppose you would call it his final will, bequeathed only the property to her. It's in the Zola Mbatha estate. She now appears to be asking for both the 10 million rand and the property, and for a 100,000 rand bequest for her grandchild. The executors say she should only get the property. Zola Mbatha is a fiduciary attorney who deals with issues like this. Zola, good morning to you. I find this a little confusing. Normally, when you have an argument about a will, it's members of the family. Yeah. If you and I were brothers and sisters, we'll be fighting over who should get the money. Yeah. What seems to be happening here is some members of the family, Foxton's children, are supporting Madonsela. Who's this dispute actually with?
Sure. Morning, Stephen. It's absolutely lovely to be here with you today. I think we just need to take a bit of a backtrack. And I say this because, firstly, we are seeing a trend where estates are now being discussed and fought in media. And media versions are always conflicting. I've read 2 articles where they've said something completely different. And this is why the press briefing that Thuli Madonsela is going to have today is so important, because she needs to state the facts as they are. From the set of facts that are in the public right now as a result of media, and not because of the will being published. Yeah. There was a 2020 will that gave Thuli Madonsela 10 million rand cash bequest as a legacy. And then there was a 100,000 rand cash legacy paid to her grandchild as well. And then everything else. And then the 2025 will that was done in February this year, and her partner then passed away in June. So that triggers the timing. It then says she gets the property in Cape Town instead. Right? So a person from a general perspective would say, but what is the issue? Because basically a property in Cape Town should be valued at about 10 million instead of the 10 million rand cash. Why is it so important for Thuli Madonsela to have this sorted out? That's the first thing. The second is the executors are putting out a message to media that we support, obviously, the 2025 will, and we support the bequest of the property to Thuli Madonsela, and that is it. The children of the deceased partner are just residuary heirs. In other words, whatever has not gone to Thuli or her grandchild or his sister, then will go into this residuary heir. The material changes that I have seen with this will is 2020 says Thuli Madonsela gets 10 million rand cash, and her grandchild gets 100,000, and then everything else goes to his children. This year's will says his sister is added. That's the material difference. His sister has been added, and her grandchild has been removed. So at this point, it could be sentimental, it could be legal tech, or it could be the fact that they are just not getting along. It's very hard to determine who is not getting along at this stage, Stephen, based on the multiple articles and the multiple facts that are floating around. And that's why this briefing is so important today.
I would imagine the only time you actually get clarity on something like this is if it actually goes to a high court and everyone has to lodge the documents and we see the will.
100%.
Before then, we're not going to know.
A last will and testament becomes a public document once it is lodged with the master of the High Court. And once it's lodged, everyone in South Africa can go view it from the master's office. We can go view Nelson Mandela's will and his file at the master's office. It literally becomes public. And then you cannot dispute the validity of a will without it going through the master of the High Court, because the master of the High Court has to either accept the will in its format or reject it. Okay.
So if you, a couple of just preliminary points, if I may. The later the will, the better, right? The last will should stand, unless there's a reason to challenge it.
Yeah, the later the will, the better. We should, from an estate planning perspective, review our last will and testament annually. Because our circumstances change. You definitely need to review a last will and testament after divorce or death of someone that was an heir. But the issue here, and I say it really is looking like it's sentimental, is that firstly, it seems like there was a conversation between the professor and her partner in 2020. She understood fundamentally that as my partner, I'm going to leave you 10 million rand. What's triggering in this instance for the professor is that there was no discussion. If he had a discussion and made her understand the first time, when the will was changed, how come there was an absence of the same discussion? Which is making her think, but this is not what he wished, and this is not what we spoke about in our love nest. So then he must have been influenced, number one. Number two, was he medically fit to do a will in 2025 and then subsequently pass away 4 months later. I see that also in the articles, they say there's a big shift where they got a handwriting expert. I don't think that's the big shift, a handwriting expert. I think the big shift is a medical report. If someone is doing a last will and testament at a time where they are sick and potentially they can be mentally altered by their health, then there needs to be an attorney present when that will is signed. There needs to be a certificate affixed to that will where the attorney says, I am in possession of a medical certificate. This person has the right mental capacity to depose to this will or to be a testator of this will. Are those available? We don't know. We'll only know either through the press briefing or once the will has been lodged at the Master of the High Court. So
just to go back to that, if there's a will that is lodged, when you sign it, does someone need to say that you're medically sound?
If you are not okay, you and I, we can do a will without a certificate. But once we've reached a medical situation where we are in a hospital, then you definitely need to have an attorney present, and there needs to be a certificate that's confirming that you do have the capacity to do this will. Otherwise, you are easily influenceable.
Sure.
Yeah.
So in these things, I mean, I have not seen at this point, you know, that the family is necessarily fighting.
Yeah.
But the executor also has a legal duty, I presume.
Yes.
So even if the family's not fighting and they all agree to, let's just say they agree to share it equally.
Yes.
I mean, maybe they are, I don't know.
Okay.
But can the executor allow that? The executor has to fulfill the person who's passed away's will. They have to fulfill that, finish and cloth.
Well, Stephen, look, I think it's going to be a bit ironic for me to say this, but I'm finding a trend where high prominent estates are being fought in public, in the public domain. And I think it's such an unfair thing because, firstly, there is a legacy here that needs to be protected. There's a man who was private and held his affairs privately. Now, all of a sudden, because he's passed away, he's become a breadwinner, and we're now fighting for his 10 million this, 10 million that. And I don't even think that's something someone of that level of dignity wanted for his legacy to be dealt down. That's the first. The second, the executors must obviously abide by the last will and testament, but heirs can do what is called a redistribution agreement. You getting 10 million, I'm getting a house. I would prefer the cash, you can have the house. Then we do an agreement between each other. Okay, take the cash and I get the house.
And the executor has nothing to do with that.
The executor has something to do with that because they need to draft that agreement and they need to lodge it at the Master of the High Court so that it can be approved. It just needs to reconcile from a monetary value. We can't change, I can't give you 11 million. Now, because we're redistributing, it has to match what the wishes of the last will and testament were. And then lastly, and this is so important, it is not the legacy of the deceased that wins when we fight in court over the estate. It is definitely not his children because the residue is going to minimize as a result of the legal cost. It's definitely not the professor because her private affairs are now being displayed. It's the lawyers.
Yes.
And that's why I'm saying it's quite ironic I'm saying this as a lawyer. And it's so unfair because once you're litigating an estate, you're paying for an advocate, possibly. We know, Peru was 50,000 an hour. And then you're paying for a senior advocate, you're paying for a junior advocate, you're paying for a senior attorney, you're paying for a junior attorney on one matter. And whereas mediation should have been the first.
Well, that was going to be my next question. Is the High Court the only option or are there other ways?
There are other ways. If the family can sit together and hold what is called a deceased estate consultation. I do a lot of those with families from all levels of estate values, from Section 18, which are estates below 250,000, from estates that are about average 10 million, and even an estate once that was valued at $1 billion. And deceased estate consultation allows people to sit down. These are the facts. And this is what it is. How do you feel about it? How do you feel? This is what the law says. And let us reconcile. And more important than anything, let us remember the spirit of the person who built this wealth.
So you sit in a meeting with people
I do.
Over $1 billion rand, and they all get on. They must really love each other.
They never get along. There's a thing, and I've said this, I do Venek videos because I want to teach people in the communities about such things. I mean, if prominent people and wealthy people are going through this, can you imagine in a family home in the community? And I say to them, there's a spirit of dispute that is triggered by death. I can't exactly put my finger on it because I've been doing this for 14 years. And it's especially if it's a breadwinner or someone that is considered, in my language, it's called imbeu, someone who's very strong, a leader in the family. When they pass away, chaos ensues. And I don't know what we can do in order to minimize it, except to realize the following. Once you lose someone you love, you are, no matter what your profession is, you can be an advocate like our professor, you can be educated like the deceased children, but your emotions sort of overtake your logic in that moment. And you need to control them because they have the ability to undo all the hard work.
Isn't that because people are, firstly, they are traumatized?
Yes, it is a traumatic
Whenever
experience.
somebody passes away, in my experience, there are always things you wanted to say or issues you wanted to resolve, no matter how much you love them. It can be your life partner, can be your parent, can be your child, I suppose.
Yeah.
But then what this is also about is if this person gets more than me, it means that they will love them more. And isn't that really the heart of this?
So it's just emotions, and human emotions make the most errors.
Yeah. Okay, best case scenario for all of this to be resolved would be a mediation meeting. Everyone sits down, stops telling us what's going on, and we wait for the master's office to get people.
100%. I mean, if they're going to court now, there's obviously going to be founding affidavits. It'd be very valuable if you and I, Stephen, could read them so we understand Thuli's professor's, version of what she's feeling, and then understand the children's version of what they are feeling, and just pause a bit with the lawyers. And their invoices, and just hear what this man's family is going through, and then try and resolve it around there. So that will be very much, I think the press briefing will also give us an idea, because there's also the whole, in the communities, there's the whole concept of how you treat the partner of a breadwinner once the breadwinner has died. And it's horrific. Now, in this instance, we're not seeing that, which is why you said to me when we first saw each other this morning, it doesn't look like the children are fighting with Thuli. It looks like it's an issue between Thuli and the lawyers, but we'll only know what the actual issue is once she does this press briefing. Because from my opinion, I just think it's a sentimental value. I find that family members who don't necessarily care about legacy are the ones that show up at the end when a person is about to pass away, and then they're all of a sudden in the walls. I'm looking to see what Thuli is going to say about the sister's role and involvement in this, because that, I think, is where the emotional clash is, not necessarily the children and Thuli, but perhaps the sister, the removal of her grandchild and the addition of the sister, and what relationship did the sister have with him while he was healthy.
When you get to a complicated dispute, and some of these disputes can go on for years, and you're talking handwriting experts and all the rest, I'm not always entirely sure what a handwriting expert can tell you. I mean, my signature is a terrible scrawl, has been forever. I prefer to use a computer to sign, I use whatever it is. And I mean, I sort of shudder if someone were ever going to try and say, no, well, this signature is, I mean, they would have no idea whether I did it or not, frankly. I mean, a signature, it's such a 1,000-year-old kind of technology. Yeah,
look, from a digitization perspective, obviously each signature has its own reference number, so it's easier to trace, actually, than an ink signature. However, a lost will and testament and master's office documents need to have an ink signature for originality. And so from what I understand, just from my work, is it's a lot of factors that these handwriting experts use, not just the matching of the signature, because we can forge, even the pressure. The way the ball touches the pen, and I mean the document, the paper, and it's a whole lot of science. And the courts use it as a very strong criteria for decision making. But in this instance, I actually think a medical report would be more valuable than a handwriting expert.
Zola, lovely. Thank you so much for coming in. Really do appreciate it. Zola Mbatha is a fiduciary attorney who deals with issues like this. We do expect that press briefing involving the former public protector, Professor Thuli Madonsela, will begin at around 12 today.